everyone. I call to order the July 23rd, 2025 Planning Commission meeting at 9 a.m. We are meeting in the Manzanita Hall as well as via Zoom. Please rise and join me in the Pledge of Allegiance. Pledge of Allegiance to the flag, United States of America, to the republic for which it stands, one nation under God, indivisible, with liberty and justice for all. Madam Clerk, please proceed with the roll call.
Commissioner Garcia,
Present.
Commissioner Gupta,
Here.
Commissioner Hanson,
Here.
Chair Serrano Kwan.
Here.
Thank you, Chair. You have a quorum and staff is Representative Monowitz, Fox, and Gonzalez. Thank you.
Thank you. We will now open public comment for items on the consent agenda and items not on the agenda. This meeting is a limited public forum. All public comments must relate to something that is within the subject matter jurisdiction of this agency. If a comment does not relate to the subject matter jurisdiction of this agency, we will interrupt your comment and move on to the next speaker. As presiding officer of this meeting, I will determine whether a comment does not relate to the subject matters placed within this agency's purview. Madam Clerk, please proceed.
Thank you, Chair. I will first call upon members in person, followed by speakers on Zoom. For in-person comments, the speaker slips are located in the back of the room. Online, please use the raised hand feature or *9 if you are calling by phone. And there are no comments for this item. Thank you.
We will now move on to item 2. Madam Clerk, please introduce the project and the planner.
Thank you, Chair. Pardon, that was my mistake. There's a section missing, but we do have to motion to set the agenda.
Motion for passing the consent calendar agenda.
Sorry.
The second.
Second.
Thank you. That was a motion by Commissioner Garcia, a second by Commissioner Gupta. Commissioner Garcia,
Aye.
Commissioner Gupta,
Aye.
Commissioner Hanson,
Aye.
Chair Serrano Kwan.
Aye.
Thank you. Motion carries.
Thank you. We'll move on to item 2. Madam Clerk, please introduce project and the planner.
Owner applicant Elizabeth Lacasia, file number PLN 2021-00478, location San Carlos Avenue, El Granada, APN 047-105-020, and your project planner is Camille Leon.
Good morning, planning commissioners and staff. We can do the next slide. The project is on San Carlos Avenue in El Granada. It's at the very end of San Carlos Avenue, on the edge of the Montecito riparian corridor, as you can see in the top slide, sort of on the east end of El Granada. And this is the neighboring developed parcel. And as you can see in the plan on the bottom, there's a 30-foot riparian buffer zone that's incorporated into the project with some in the air encroachments into that area. But otherwise, the development conforms to the buffer zone. It's a legal conforming, actually oversized, 7,070 square foot parcel. The Montecito riparian corridor is right there. It's on the edge of it. The corridor is based on an intermittent drainage channel that's sometimes referred to San Agustin Creek. That's approximately 116 feet west of the project site. And the property is located within an existing residential neighborhood with access proposed from San Carlos Avenue, a public roadway. These are elevations of the project. On the left is the view you'll see from San Carlos Avenue, with a garage that comes out further to the street. And it's a 3-story structure. This is what you'll see on the right, is what you'll see from this side view, I believe. Perhaps that's the rear view. That's the rear. So that's, the property drops off towards the Montecito riparian corridor at the rear of the parcels. And these are the side views of the project. You can see that the garage comes out. It actually goes into the front setback. So they're seeking a variance of approximately 3+ feet from the edge of the right of way. Oh, actually, I wanted to point out one other thing on the other slide. The ceiling heights are actually pretty low on the bottom and the second floor, leaving a higher ceiling height, but not that much higher ceiling height on the top floor for a vaulted ceiling. So the encroachments into the 30-foot riparian setback are listed here and also listed in the staff report. But what's noted is the decks are pervious, so they allow water to go through. And most of the encroachments are in air. They don't directly affect, especially on the third floor. So you'll see most of the encroachments on the third floor. They don't directly affect the riparian vegetation below or habitat. On February 13, 2025, the Coastside Design Review Committee reviewed and recommended approval of the project. They found that the design appears proportional and complementary to other homes in the neighborhood and conforms to the natural topography of the site. The scale of the front entry is compatible with other features of the house, but for better compliance, they added a condition for the applicant to replace the board and batten siding on the south elevation pop-out with stucco, and also to reduce encroachments into the buffer zone, and that included a deck post that has since been removed from the design and a downspout, so that it's kind of more of a cantilevered encroachment. With regard to zoning and LCP conformance, with the exception of the front setback, it does conform to the R1S 17. And as outlined in the staff report, in terms of the sensitive habitat component, the staff report goes into a great deal of discussion regarding the project location near the Montecito riparian corridor, and lots of bio reports over these many years of processing this project. But there was a riparian analysis, but there is something a little complex, I guess, about the wetland analysis. There was a site-specific wetland analysis on the parcel, but not a site-specific wetland analysis within all areas, including outside areas, within that 100-foot buffer zone to the actual building envelope, building footprint, which would be needed in order to put the project outside of the 100-foot wetland buffer, and also outside of the Coastal Commission appeals jurisdiction. So that site-specific study was not done for those offsite areas. So we don't have conclusive analysis that says this is not within 100 feet of a wetland and not appealable to the Coastal Commission. So because of the potential intrusion into the 100-foot wetland buffer, the applicant has asked for relief from that, and which is offered through California Coastal Act Section 310, that if an applicant for a CDP can demonstrate that denial of the proposed project based on application of Coastal Act policies would constitute an unconstitutional taking of private property without just compensation, some development may be allowed even where a Coastal Act policy may otherwise prohibit it, unless the project would constitute a nuisance under state law. So with regard to that finding, staff finds that the property owner has sufficient real property interest. They've paid just for the land $310,000. Staff received proper documentation of that. Denial of the project based on application of the strict Coastal Act policy with regard to wetlands would deprive her property of all economically viable use. The subject property is 50 feet wide. So depending on, so if wetlands were to exist on any of the adjoining lands, the application of a 100-foot wetland buffer zone, you could see would significantly constrain development and prohibit development of a reasonable size house on the property. Also, the residential project fits with the residential zoning and would not constitute a nuisance under state law. So staff did prepare and publish an initial study mitigated negative declaration, which was released in April 2023 with a 20-day comment period. Most of the analysis focused on the impact of biological resources. We did receive a comment letter from Committee for Green Foothills stating that the project required a CDP, which staff agrees with, based on the wetlands explanation I just stated. Also, we received a comment from the neighbor at 771 San Carlos, which is that first adjoining neighbor, that the project appears to come within 15 feet of the riparian boundary instead of 30, as evidenced by the drip line of the arroyo willow canopy, where a minimum of 30 feet is required. The project biologist has responded to that comment, stating that it's the riparian corridor boundary is not established from the drip line. It's established where there's 50% cover requirement, and the project biologist, who's been on this project since the very beginning. And it's been a while for this project, at least since 2003. Thank you. Okay. So we've pretty much had a very, continuous, the biologist has been the same, with kind of continuous understanding of it. So he's here if you have any questions regarding that. Even though there's been slight project changes, there's no change necessary to the mitigation measures of the initial study negative declaration to address these concerns or comments, nor the concerns and comments that the Planning Commission received recently. And the mitigation measures are included in attachment A as conditions of approval. So with that, staff recommends that the Planning Commission adopt the initial study mitigated negative declaration and approve the design review permit, coastal development permit, and variance, county file number 2021-478, by making the required findings and adopting the conditions of approval in attachment A. Thank you. And staff is available for any questions, as well as the project team.
Thank you. Do you have any questions to staff from the commission?
The question, the property, well, the lot adjacent to the undeveloped lot adjacent to this one. Okay. How is it zoned?
It's the same zoning.
Same zoning?
Yes. Yes.
Okay. And it's further toward the riparian zone? The
riparian, yeah. Each of those parcels in the Montecito riparian corridor, there was a map done in the 1980s, I believe, that estimated various levels of cover of vegetation on each of the parcels, with obviously a little less around the boundaries. But we would rely on a site-specific and current biological report prior to issuing any development permits on any of those parcels.
Okay.
I could add to that a little bit. So when our zoning for this area was established, it didn't really address the riparian corridor known as Montecito Riparian Corridor. And what we've encountered over the years are development proposals in that area, that seek to develop residences similar to other residences in the neighborhood. However, the presence of this riparian corridor is indeed a constraint that we need to deal with under the Coastal Act and our local coastal program. And when, this issue was identified in the 80s, the county, the Planning and Building Department did what we could to inform property owners of the constraints presented by the Montecito Riparian Corridor. And I think, this project, which has been many years in the making, has really strived to respect the riparian corridor protections while also achieving a reasonable economic use. Within this riparian corridor, it's very site-specific analysis to ensure that we maximize consistency with the riparian protection policies of our local coastal program, while also allowing a reasonable economic use of private property. And I think through the years of working with the applicant here and assessing the resource to the best of our ability, we believe that a balance has been achieved by the current proposal.
Any other questions to staff and commission?
Maybe later.
So at this time, I had this question. So at this time, what are the different variances in front of our commission that we are looking at approving? Or
Yes.
it's in front of us?
Right.
To approve?
It's described in the staff report, but the variance proposed is a variance to the front setback of 20, the required is 20 feet, where only 3 feet is proposed. In order to basically move the house away from the riparian corridor, have
Right.
it meet generally the 30 feet buffer zone, but with a reduction of the front setback. And
the-
DPW is fine with it. Fire has signed off on,
Okay, that was my
the need
next
for
question on
yeah.
that.
Just to be clear on that point, it's 3 feet, it's an adjustment of 3 feet, or it's 3 feet total? The adjustment is 3 feet, or is,
The adjustment's 17.
okay.
Yes, and I'd just like to note staff support of the variance, because when it comes to what's more important, front setbacks or riparian habitat setbacks, we would put the habitat protection as a higher priority. I'd also observe that, this is kind of at the end of the road, right? So encroaching into the front setback becomes less of a problem due to the fact that it's at the end of the road. And like I said, it's what's needed to maximize protection of the riparian corridor.
For the 3 feet?
Yes, by providing relief from the requirement to set back 20 feet from the front property line, it
Right.
allows the home to be further away from the habitat we're seeking to protect.
In the back?
In the back,
In the
correct.
back, right. So we are also looking at giving, like approving a variance in the back also.
Under the
right? It
CDP.
should be,
Under the Coastal Act. Through the CDP.
like it,
For the wetlands,
100, right,
Yes.
in the wetlands
Yeah.
area.
correct.
Oh,
Under the
right,
CDP.
right. That's so in the front, we're allowing the home to be closer to the road in order to maximize the distance from the riparian setback. But even with that movement of the home closer to the road, we don't have assurance that it meets the 100-foot distance from the wetland. Notwithstanding that fact, we believe the applicant has made all the appropriate adjustments to provide maximum protection of that habitat while still enabling a reasonable economic use of the property.
So what is the required, what is the word I'm?
It's 100-foot buffer,
It should be 100.
100-foot.
For
And
wetlands,
what-
yes.
Right, for the riparian,
Riparian's 30.
right, for the riparian
Buffer zone is 30 feet,
zone, right.
of which the project
And we
generally
are,
meets.
and the applicant is asking for 30 feet?
30 feet is the required, and they
30
generally
feet
meet
is-
it with some inerrant encroachments, minor.
Okay, so you are, so that's what you pointed out,
Yes.
that it's in the air.
That's
it's
correct.
Not on the ground.
That's correct.
So, okay, okay. So essentially that is, it's not a variance.
The variance is for the front setback, right?
Of,
right. Yeah.
right, so, okay, so for that, go ahead.
Okay. And do you have a new question based on your comments? In-air encroachments, what are do they need to be explicitly called out and allowed for?
I think it really depends on whether or not we think that the in-air encroachments will have an impact on the protection of the habitat values. By limiting it to, things that are not impacting the ground, we preserve that land area as a buffer. I think there are potential impacts with in-air encroachments associated with light and noise. However, I think these are, reasonable requests based on what is a common residential design.
Maybe a different phrasing. Do the in-air encroachments require a variance from this body?
No, we are not issuing a variance for those. We are just recognizing that they are part of a reasonable economic use, and under the provisions preventing it taking a private property, we think they should be allowed.
Did I? Before. Thank you. So is there another parcel on the other side which is not developed, which may come up for new development? Right now, we are saying it's okay to build this home with only 3 feet
Front.
from the street. And
I think I can respond to that question. There are other vacant parcels in this corridor that have similar situations.
okay,
And I think in all of those cases, we have a similar objective to maximize protection of the riparian corridor while also allowing private property owners who have a reasonable economic backed expectation to make use of their property. And so, as I mentioned earlier, these are case-specific assessments where we look at the particulars of each property and we perform what's essentially a balancing act of maximizing resource protection while also allowing a reasonable use of the property.
so the riparian corridor we are prioritizing that buffering there.
That's correct. And I think that's what's required under the Coastal Act and our local coastal program.
Because some of the public comments have brought up the parking issue, because when we bring the home almost close to the street, there's no driveway there. All the parking is out on the street, other than the garage. And with the ADU, you may need more parking
Right.
than just the 2-car garage.
DPW and fire have reviewed the project without requiring a red zone. It was wide enough to meet their requirements without the concern for parking.
Okay, okay, thank you.
Thank you, Commissioners, for your questions. Does the applicant wish to speak? You have 15 minutes.
Good morning. I'm Jason Silva with Hawk Design and Consulting. I'm representing Elizabeth today, helping her with her project. I've been on this project for about 4 years. Thank you, Camille, for all your hard work the last 20 years. Mostly, and Steve for examining the project thoroughly. I appreciate the staff report. Staff report does say in 12.3 that there's no substantial evidence that the project has a significant effect on the environment. We're proud of that. Our clients actually inherited the property when they bought it. And unannounced to them, undisclosed to them, they bought the property. And the past owners had messed with the riparian. They had played with the riparian, cut it back a little bit. So our clients have been restoring that for about 10 years just to get it back and then go through this process. So we're proud of the project that it's accomplished that. There are other properties adjacent, immediately adjacent to this property that was allowed a 20-foot setback recently and built the deck within the 30-foot buffer. They tore down the deck and built a new deck, and they did all the work that we did. They had the same type of species of plants as we did, and they came back not well, they came back and the willows were not wetland willows. So most of the properties in it that were developed have willows, none of which were wetland willows. So what I wanted to express today, especially, is that we have Robert Piera here with Huffman Broadway Group. He's a senior wetland regulatory scientist, and he has determined that I quote here, property does not support wetlands as defined in the San Mateo County local program. So not only has this staff report said this is that it has no significant impact on the environment. Also, Robert Piera says there is no support for wetlands in the area. There's no support that there is a wetland, so a 100-foot buffer would require a wetland to be there. There's a could be out there because some of the adjacent properties haven't been tested, but all the ones that have been tested, that have been developed, that have went through the permit process, all show no wetlands. And we're surrounded by properties except for the immediate north of us. And that's where our 30-foot buffer is off of that property. So I wanted just to stress that, that there are no wetlands established. There's no evidence of wetlands. So we have no historical wetlands in the area. But if there was there could be wetlands, we would have a 100-foot buffer. The LCP does allow for a 50-foot buffer if in fact there's no other area to build on. Our property is actually, looking at the stop clock here, I feel like I'm in a boxing match. Our property is only 831 square feet of the living area is only 831 square feet of the lot. So we're on the far east, southeast corner of the lot, and we only have 831 square feet of that lot. That's why the house is kind of like a tower, because we're trying to accommodate the setbacks. And then 371 square feet of the garage is on the lot, on the dirt. So that's the only part of the land that we're affecting is 831 square feet for the residents, and then 371 square feet for the approved garage, which we need for parking. And that answers the parking question. So I hope that helps this morning. Do you have any questions for me?
The wetlands expert, is that person present?
He is present. He would love to speak also today to kind of give his analysis of it, because he's better at that than I am, of course. And the biologist is here also, who did the wetlands, who's been involved in this project for 20 years, trying to restore the wetlands on the area that was disturbed by our client. Any other questions?
So I was looking at the chronology of this parcel, and some years ago, I read that some of the riparian vegetation was removed illegally. Could you
Yes.
talk more about it?
Yes, I absolutely.
What does that mean?
Thank you for the opportunity to talk about that. So what happened was the previous owner to the lot had went in and cleared out some riparian. This was not the owner who purchased the lot, but the previous owner had done that damage. So our owner of the landowner of this parcel today, who's the applicant, she and her husband had to get a biologist involved to restore that riparian that was damaged by the previous owner. So, and that work's been done and accomplished, and it needed a CDP for that. And I think that's all been approved. which came to the conclusion in 12.3 on the staff report that there is no longer any environmental impact on the lot as a result of this project.
So just for my information's sake, do you have to do something about restoring it, or does it come back on its own?
That's a great question, and I would appreciate if the biologist could answer that for you. He'll come up and
Okay.
answer that for you. I will mention that it's not uncommon, unfortunately. The lot right next to us did the same thing prior to getting their analysis for their deck. And they cut back some riparian, and then they went in for the variance for the deck, so they could build in the 30-foot buffer, and they got the 30-foot buffer, and I don't think they had to do really any restoration. But our client did have to do some restoration. The understanding of that I don't have, so the biologist will help us today understand how they did that and why they did it and how much
Okay.
it helped the property, the environment.
And if I could add to that, Commissioner Gupta, you know, per the conditions of our approval, that wetland buffer area will need to be retained and preserved as habitat. You know, further encroachments or use into that of that area will not be
Okay.
permitted. And so through a combination of taking a hands-off approach and requiring the removal of invasive species, we would expect that riparian corridor to become restored.
Okay. And just more again, for my information, do they need any kind of permits to, when it said that it was illegally, like vegetation was removed, do they need permits to?
So the action on today's permit should resolve that.
Okay.
And I think, you know, the terms of, the recommended terms of approval will ensure that it will be protected over the long term.
Okay.
I think we've heard some discussion about the over air encroachment, and whether or not there's a support pillar that exists to anchor that deck.
Great, what?
I've heard cantilevered. I've seen on page 50 of the staff report, there's a what appears to be a post. Is it there or is it not there?
Thank you for asking about that. We're gonna remove it.
Okay.
That's part of the condition. We're gonna remove that post. And we're gonna actually knee it off the building with some structural steel. It's a costly process, but we're gonna do that. But it was just a little 6x6 area in that 30-foot buffer, yeah.
Yeah.
And then just to add to that, the cantilever sections are so high, like they're 12, 13, 14 feet off the grade.
Mm.
So those are, you know, quite a bit high off of the grade. And then they're pervious also. Some of it is pervious. So it really keeps us out of the buffer as far as the envelope goes. And then gives us plenty of space for riparian to grow right up against the building. So if it does grow that much. I'll also note that the CDRC, they ensured that the new development of this home with all its restraints was compatible to the neighborhood and the physical characteristics, and they approved it. And that was quite a process, and they gave us great input, and we adopted all their input. And that's how the project became how it is today through the collaboration of the CDRC and Camille and ourselves. That's how we ended up with this design.
Likewise, beyond the post drain spouts, I mean, I guess
We
these plans.
moved those
Okay.
too. Yep.
Do you have, are the updated versions of those?
You know, I thought we sent those in. I don't know if they landed or not, but that is something else that will be a condition.
Okay.
Yeah, absolutely for approval. We already done that on our end, but it may not have landed on your end. My apologies.
Commissioners have any other questions? Thank you.
Thank you.
We will now open public comment for item number 2. Madam Clerk, please proceed.
Thank you, Chair. I would like to note that we did receive 5 written correspondence for this item, and it was circulated to the commission. And at this time, we have 3 persons wishing to speak in person, and I'd like to ask our participants on Zoom to please raise your hand at this time if you wish to speak. And I will first call on David Allen, followed by Susanna.
Thank you.
Oh, right over
For organization, there's a speaker on Zoom who's from the Green Foothills Council, and is it possible to ask them to speak first?
We're going to proceed with comments in person.
Okay,
Sure.
that's fine. So, hello, my name is David Allen. I live at 736 San Carlos, which is directly across the street from the proposed building. I have quite a number of comments, actually, and unfortunately, the made several comments which I don't want to directly contradict. The next door neighbor person that he mentioned a few times wasn't able to come, but he's presented in the past at the Planning Council meeting at the architectural review some information which is kind of the opposite of what Jason said. So there's a couple points that I want to make. Thank you for having the timer on. Fit in. I think one of the main points is the definition of the exact riparian boundary, right? So there was mention of illegal cutting, which may have been 30 years ago, I think. There was recently some cutting just in the last 6 months that I think Jason's team did. So there's some question about where exactly to draw the riparian boundary. I think the speaker from Green Foothills may have something to say about that. The biologist may also have something to say. But that's kind of critical. If we move the boundary one way or the other by 10 feet, that greatly restricts the amount of buildable area. So that's something that I think we need to look into a little bit more, and hopefully the other speakers will address. Another point that I wanted to make is about the in-air encroachments. So the next door neighbor that Jason mentioned a few times, I'm not personally aware of any cutting that he did, but I do know, and this is on the record from his previous written statements to the architectural review, they attempted to extend their deck, which is the drop off is steep. The deck is at least 30 feet in the air. They applied maybe 8 years ago or 10 years ago to extend the deck. They needed to rebuild it. And it was denied because in-air encroachments were not permitted. And that was specifically denied previously. And he can account for that, but it's in the written statements that he's made previously. So we're a little, I guess we don't quite agree with the idea of in-air encroachments because the neighbor, the immediate next door neighbor, was denied in attempting to do the same thing. So that's one point. There were a couple of comments made about parking. I just want to go back to that. So the diagrams don't show, but there's a fire hydrant, which is when the story poles were up, the fire hydrant is, I guess, exactly 3 feet from the wall of the house and exactly 3 feet from the driveway, which is the minimum, okay? But it makes us nervous because especially given the lack of on-street parking, it's highly likely that cars would be parked there and could block the fire hydrant access. The comment was made in the written comments about parking. The street is not a county road. It's a little bit narrower than county roads. It's a private road. And there is in fact one house beyond this. You can see clearly on the site map. There's one house which is beyond. So if there's some obstruction of parking cars and there's some fire either at the house or a medical emergency, they would not be able to reach. So we're strongly opposed to parking. We feel strongly that parking will be a problem, especially with the ADU. This is the third development, the third proposal that we're aware of for this property, and they keep getting bigger. And this one has an ADU, which makes the parking problem even worse. So we're pretty concerned from the standpoint of safety, both fire and medical, for other houses on that road. In terms of there was a comment about reasonable economic use. Sorry, this house is huge compared to the other houses in the neighborhood. It towers above the skyline. One of the other speakers will show. It's 3 floors. The other houses are 2 floors. It's required this setback to the street in order to increase the square footage. There are other houses in the area on the street which are, let's say, much more reasonably sized for their lot. So in terms of fair economic use, the lot, we agree the lot is buildable. We're not disputing that, but not at that scale. A smaller house that didn't require the setbacks, that didn't tower over the neighborhood, you know, fewer of the neighbors probably would gather here to object. So let me just check if there were other points that I wanted to make. No, I think that was everything.
Thank you. I will now call on Susanna Van Bozoyen, followed by Roel Van Bozoyen.
Thank you. So my name's Susanna Van Besoyen, and I live at 730 San Carlos Avenue. I've lived there for 30 years. And in those 30 years, when I first moved in, there were 5 houses on the street. I believe there are now 10. When I moved in, both Paloma, the street that crosses San Carlos, and San Carlos Avenue were dirt roads. Now, Paloma was a county road. Shortly afterwards, it was paved. The owners got together at one point in maybe around 2020 to pave the road ourselves. We paid to have someone come. So it's not a standard road at all, as was mentioned. So there are no, it's very random where parking is, and it's not perfect, the street. So I just want to reinforce the issue of parking. When a fire truck, an ambulance, or today there was a big moving van yesterday evening, that van has to back up all the way from the dead end street where there should be a cul-de-sac. We wanted that, but because of the willows, we couldn't have one. The van had to back up all the way down the street to the crossroads, back uphill, up Paloma, and then down. So it's really awkward if there's an emergency. And then another thing I want to stress is coming, because I grew up in the Bay Area and came frequently to the coast side, I've watched the coast side change. And I just want to stress, in 1960, there were butterflies in the grove of eucalyptus. Monarch butterflies came every year to host, like they do in Pacific Grove. I did see monarch, a few, like maybe 25 monarch butterflies hosting 2 years ago in a very, very wet year. Now, as you know, California is kind of a subtropical environment. We have a dry season and a wet season. We don't have 4 seasons. We have 6 months and 6 months. So the willows are sometimes more dry and sometimes wetter. There have been years when there have been, the streets on that side have had a lot of water in their basement. And they've had to do a lot of different drainage and reinforcement because of the water that comes down the hill. There's the actual creek, which does flood Balboa, even this year, which wasn't such a wet year. But the year before, it really flooded. It was very difficult to drive through that lowest part. Balboa is the street below San Carlos, where the willows, where the creek ends, because it was put in a culvert. And so because the creek goes into the culvert at that point, the creek widens a lot, and a lot of water goes into the street on either side. Now, right now, in a dry time of year, you don't see that. So when you do the study, I don't know, I'm not an environmentalist. I know my son does these studies, but he said it varies a lot when you look at land, whether it's what season it is. And the other thing that happens is every time development happens, a lot of encroachment on willows and other natural habitat happens because of all the bulldozing, and even though you have that's why they set a 100-foot barrier with, as I understood it, a variance with an appeal to the Coastal Commission of 50 feet, and then that can then again be appealed to 30 feet. Now, I guess that would be for this economic hardship issue or something like that. But there are small houses in El Granada that are only 2 stories high and that wouldn't tower over. This is a full story above the house next to it. And it will be only, I don't know, is it 5 feet or something next to that house? So that it's very imposing. And if it were a smaller design, as David said, it would be less objectionable and would also have less impact on the environment. There were quail in the street. There were garter snakes in the street. I used to find so many garter snakes in my garden, and I'm quite a ways from the creek. Now, I think every year I find one or two garter snakes in my, and the same with the frogs. Every night we would hear frogs singing, whole chorus of frogs all summer, in the all winter. In the summer, even we would hear them. Now you maybe hear one or two frogs. So it is a danger, and I think it's a treasure, having grown up there and lived there for 30 years. I really think often when new people come, they see the beauty and they love it, but they don't realize that if we don't take care of it, it doesn't last. It goes away and it doesn't come back. So thank you very much.
Thank you. I will call the last speaker in person, Royal Van Bezoyen.
Thank you. My name is Roel van Bezooyen, and I've lived in that place for 35 years and seen a lot of change over there. I fully agree with the previous two speakers that this project is out of scale because it towers 8.5 feet above the neighboring house, which is a very large house. And the idea was, since the buildable percentage of that lot is small, we just have to go up to 3 stories. There's no other 3-story house on the lot on the street. So it looks like a wall if you live right next to it. And about 20 years ago, when this lot was for sale for the first time, my wife encountered somebody, a prospective buyer, who looked at the lot and he said, I cannot build anything of any size on this lot because it's just too small with the riparian corridor so close. So he decided not to buy it. He said he could only build a little house. If you use the 50 feet buffer relative to the riparian area, the amount of buildable area is only 85 square feet. So it's very questionable whether you can or should be able to build a big house like is being proposed at that location. Then right now there's a sign saying no parking, fire lane, right on the street boundary of the property, which indicates that parking cars there is not a good idea. It's actually illegal. And with the ADU, there would be 2 additional cars probably that needed to be parked there. So that's a real problem. Yeah, that's all I wanted to say. Thank you.
Thank you. We will now move on to Zoom comments. And I do see the owner, Elizabeth Lacasia, has her hand raised, so I will call on her first, followed by Jen Allen.
Hello, can you hear me?
Yes, go ahead.
I would like to preserve my time and speak at the end of the meeting if you don't mind.
Sure.
Thank you.
Jen Allen, go ahead, and then we will call on Lenny Roberts. Jen Allen, please unmute your mic and begin speaking. Okay, we'll move on. We'll move on to Lenny Roberts. Lenny, go ahead.
All right, can you hear me now?
Yes, go ahead.
Okay, thank you very much. Good morning, Chair Serrano Kwan and Planning Commissioners. I'm Lenny Roberts, speaking for Green Foothills. We have been concerned about this property for decades, dating back to the initial illegal clearing of the property by the prior owner, and noted that the restoration of the property that was required did not succeed because there was no water to water the replacement plantings. So they all had died after 3 years. So that was an unfortunate attempt. That's not necessarily the fault of the current owner. But I do want to point out from the letter that I sent to you that we have been involved for, as I said, for many years in commenting on this. And on February 25th, I sent planning staff a comment letter which focused on the presence of wetlands on this property. Because arroyo willow is both a riparian and wetland species, that information was not included in your packet, and this is a significant omission. For purposes of this hearing, I'd just like to summarize the points that I had in my letter to you. Mrs. Toni Corelli, who is a noted coastal botanist and author, she included arroyo willow in a YouTube presentation on wetland plants. That was a public presentation that she did a few years ago. In that presentation, she described the fact that arroyo willow is the most common willow along the San Mateo County coast, and that arroyo willow is found in both. She specifically said that is found in both riparian and wetland habitats. They've also been, arroyo willow thickets have also been documented on otherwise steep and dry coastal hillsides, which are even less likely to be found there than here, where we have an adjacent stream. But even on dry coastal hillsides, they can occur in isolated wetland areas created by seeps and springs. One example is the Pilarcitos quarries vegetation map for when they did their mining and reclamation plan, which depicts a dozen, or which actually maps a dozen or more arroyo willow thickets on the steep hillsides. And they note in the commentary that thickets of willows also frequently are found on steep hill slopes where seeps and springs may occur. And then finally, the Coastal Commission staff biologist and staff, and in one case, and staff ecologist on another case, have determined recently that under the Coastal Act, the arroyo thickets delineate as a wetland on the basis of their facultative wetland indicator status, and therefore must be treated as wetlands under Coastal Act Section 30233. That's the first item that was in Pacifica. The second one was in the unincorporated area of San Mateo County in El Granada on the hillside, where the staff biologist concluded that the arroyo willow thicket should be considered a wetland under the Coastal Act and the local coastal program. We were also concerned about the findings for the variance, and I'm happy to have heard the discussion that the commission has had about that already. What we do have is a mapped, a very carefully mapped depiction of the different lots in the riparian, in the Montecito riparian corridor. It's on the county's planning department website, and it is referred to frequently in cases like this one. There are something like 25 to 30 similar undeveloped parcels within either within, totally covered by the riparian corridor, or in the buffer zone, the 50-foot buffer zone, per the county's map, which is dated January 28, 2014. So this property is not, is one of many properties that face this problem, and we have been urging for years for the county to do a more comprehensive approach to deciding how to deal with these many undevelopable parcels. So thank you very much for the opportunity to comment, and I look forward to, I hope that you will continue this item in order for the applicant to come back with a significantly scaled back project. Thank you.
Thank you. I will call on Carolyn Deutsch, followed by Jen Allen.
Good morning. My name is Caroline Deutsch. Thank you for giving me a few minutes to speak. I am a new neighbor on the street. I live at 754 San Carlos, and I just wanted to reinforce the comments that were made in regards to parking. I'm the person who had the moving van here yesterday, and it definitely, as the previous speaker said, took up the better part of the street. So another car wouldn't have been able to pass at that point. So the safety concerns in terms of fire and in terms of parking, I just wanted to echo that. I also wanted to say that, you know, no ill will to the person who owns that lot, and I understand the desire to build. But in looking at the homes on the street, the plans that are submitted are significantly larger, and I think it will really tower over what is right now a fairly quaint, nice neighborhood. And so, you know, I'm somebody who believes strongly in respecting each other as neighbors and kind of working together as a community. And I think that if plans were submitted that more accurately matched the feel of the street, that people who live here would be more in favor of it. And then lastly, the distance from the street. I'm actually looking out at that property right now as I'm talking to you. There is the concern with the fire hydrant, and then just the street actually narrows quite a bit right in front of my home and adjacent to the lot that we're discussing. And if a home was built directly there, it's questionable whether two cars could pass on that point of the street at this point. When I visited the home before I moved in and there were gatherings on the street, it's a very social, great community. When people are parked on the street, it is a challenge, and I can fully understand the concerns about fire and ambulance, especially in the climate that we live in, and you know, the wildfires that have been of issue in California of late. So thank you for considering. Like I said, to the person who owns it, I look forward to meeting you if you do end up living there, but I would just strongly encourage you to consider hearing the voices of what are soon to be your neighbors and trying to find something that blends in more with the community. Thank you for your time.
Thank you. I will now call on Jen Allen. Please accept this request to unmute your microphone and begin speaking.
Hi, this is Jen Allen. Can you hear me?
Yes, go ahead.
Oh, excellent. Sorry, I used to work for WebEx, so I'm not allowed to use Zoom. This is very strange for me. I'm also standing at my window looking at this lot, and I'm looking at the beautiful trees, and I'm looking at the fact that there's not going to be a lot of parking. And there's no way they can go in there and build a house of that size and not disturb a lot of what's so special about this riparian corridor. And I want you to think about the fact that all these neighbors are spending so much time and so much effort fighting this for 20 years. There's a reason. It's not just that we're stubborn. These houses have been built up on this road quite a lot for the years, and they don't get fought like this. It's where they want to put it, and it's the size they want it to be. It's got to be scaled back. And they talk about the economic use. Well, the entire community is joined together, and we've made offers on the property which have been ignored and refuted more than she paid for it. We want to pay her fair market value for the lot just to protect it. So that says a lot that our community is willing to do this for a bunch of trees. That's huge. And the setbacks they're asking for, the house sitting on the road, the fire hydrant, the emergencies, these are all true. But there's also a heart and soul to be considered here. And it is going to be a huge house, and it's not in keeping with the houses around it. And I mean, I just get really emotional about this because, like I said, I'm sitting here looking at this magnificent view and thinking about what this house is going to do to disrupt all of what we've got here. And that makes me very sad. So yeah, it could be built if you scale it back, but please let us buy the lot and protect it fully. I don't understand. That's all. I'm sorry. Thank you very much. That's all I have.
Thank you. And there are no more public comments, but I believe the owner would like to have their time back, and they have 11 minutes and 35 seconds left of their presentation. So I will call the owner, Elizabeth Lacasia.
Can you hear me?
Yes, go ahead.
I would like to speak at the end of the meeting. I'm sorry, I did not make that clear.
This is the end of the public comment. This is your last opportunity to speak, Ms.
I
Lacoste.
see. Okay, great. Thank you. I appreciate that clarification. Good morning, Planning Commission members and Camille. Thank you for listening to my perspective. My name is Elizabeth Lacasia. My husband, Rod Lacasia Barrios, and I purchased this parcel to build over 20 years ago in 2005. Rod wanted to design our home and live on the coast because he loved to sail. We have submitted 4 separate project development plans to San Mateo County Planning Department over the last 20 years, which had been approved and then later overturned. The current structure and its design envelope has been extremely restricted, more so than any other similar property in the area. The structure's residential footprint is only 831 square feet. There is no alternative to this structure. Its extreme constraints are a result of the big concern that a wetland might exist within the proximity of this development project. Is this assertion of a wetland reasonable? In light of 20 years of environmental studies on this property showing that a 75-foot zone has been proven not to contain wetland, and other county and other objective third-party reports show the likelihood of wetland to and beyond the required maximum of a 100-foot zone buffer is highly unlikely. My question is this: for the 20 years we have owned the property, why is it only now that the possibility of a wetland be raised, let alone taken seriously enough to incur such a substantial impact on the building envelope of this particular development project? Please put this unlikely concern to rest. I ask you to honor my rights as a property owner. I ask you to give me the same consideration regarding setbacks and restrictions as has been given to my neighbors in their development and remodeling projects. Please approve this project and determine there is no need for a coastal commission review. Thank you. I greatly appreciate your consideration. Please approve my project. Thank you.
No, I'm sorry, public comment's over. And with permission from the chair, we've received a lot of comments today, and if it's okay with you, I'd like to provide a response.
Yes, please go ahead, Steve.
So there's no question that this neighborhood and the site of the proposed development is highly constrained. The neighbors live with it, they observe it. But when we start suggesting that one more home on a established private property is going to tip the threshold, it becomes concerning because it does place the county in a very tenuous position of denying someone a reasonable economic use of their land. Now, as has been noted, you know, we have been at the staff level doing our best to maximize protection of the natural resources on the site and adjacent to the site. Clearly, there's disputes about the extent of wetlands, the distance of the setback, but the bottom line is this project has a 831 square foot footprint in an effort to provide maximum protection of the surrounding habitats. 831 square foot footprint. It's difficult to build a reasonable house with a smaller footprint than that. And that's the reason why you see a 3-story proposal, which, by the way, is consistent with the zoning requirements. They are not asking for a variance to height limits. The home is 1,670 square feet. That's not huge. I think one of the speakers mentioned that the house next door is huge. I wouldn't be surprised if it's larger than 1,670 square feet. Now, there is an additional 791 square foot ADU, but as this commission is familiar with, state law protects the ability of property owners to include an ADU within their proposal. Concerned about parking in front of a fire hydrant, that's illegal. We can't assume that somebody's going to be breaking the law. Nor would it be in their interest, right? Whoever owns this future home, whoever lives there, they want to stay safe too. Everyone knows that you don't park in front of fire hydrants. With regard to the fact that there are other vacant properties within this corridor, that is a real issue. And as I mentioned earlier, these are all very case-specific analyses where we carefully evaluate whether or not the owner of that property has a reasonable economic backed expectation. And if they don't, then we would not provide the same allowance. So it's not as if we can have a standard formula for all these properties. They need to be looked at individually. And in each case, we will seek to maximize resource protection and allow for a reasonable economic use. And I believe that's what we've achieved here. So I'm happy to answer any further questions you might have.
Question from the commission?
Director Manowitz, the thing that the owner brought up about potentially there is wetlands. I can't remember her exact words that she used. Could you comment on that?
Yes, I'd be happy to. A lot of the speakers have touched on this item. Lenny Roberts from Green Foothills talked about, when Arroyo Willows may or may not be wetlands.
Right.
And I don't think the project biologist has looked at this. They've determined that the stands of willows are not wetlands. That can be debated. Where we wind up as staff is whether or not they're wetlands. Has the development done the maximum possible to protect them? And based on its very limited square foot, we believe they have done the maximum to protect the habitat values, be it riparian or be it wetland.
So nothing different would be done if it was confirmed that it's wetland.
Not in my opinion. As I said earlier, I think the applicant has done what's reasonable to minimize their encroachment within whatever habitat value is adjacent to the property.
Thank you.
I'm actually curious about your point was that the delineation of wetland zones, the definition, can be debated. I don't understand.
Sure. Arroyo willows are without a doubt an indicator species, but the presence of a willow does not always equal the presence of a
I'm
wetland.
not disputing that.
Yes.
What I assume there's a well-documented definition of what is or is not a wetland. And
That's
correct.
correct.
It should be possible to make a finding on those bases. I mean, I kind of want to hear from the biologist.
Oh, sure. Well, I'd be happy to turn to the biologist to respond to this. I think the biologist has done that analysis and they have concluded.
But your phrasing, it can be disputed. What is disputable about it? Like, how can you debate? There's a definition, it meets it or it doesn't.
Commissioner Garcia, we deal with debates between experts all the time.
Sure, but I'm only hearing one expert side. Is there an expert from the other side arguing the opposite position here? Is there an expert debate?
I can't speak to the expertise of the speakers,
Okay.
but I do think that the biologist, who's a qualified professional, it would be worth hearing from them on this topic. If at the commission's pleasure, of course.
I would certainly be in favor of hearing from the biologist.
Yes, please. Podium, please. Thank you.
Thank you, Commissioners. My name is Robert Pryor with the Hupman Broadway Group. I'm a wetland scientist, and I was asked by the property owner to make an assessment on the actual property and determine whether there were wetlands on the property. Because of the arroyo willows that are on the property, those questions on whether those arroyo willows were acting as wetlands or just a riparian habitat or riparian zone. So I went out, conducted an assessment, took soil samples, looked for hydric soils, looked for wetland hydrology, and determined that there was no wetland hydrology, no hydric soils within the area where the willows were growing on the property. And so based on that, we could determine that those willows are not acting as wetlands, but they are acting as a riparian zone.
Just for my layman curiosity, how do you come to that? Like, what is about the soil?
Right. So what I did was I took a hand auger, I dug soil pits in areas where I thought soil or where I thought water could pond. Right. So you don't have the report in front of you, but I took the soil pits at the lowest end of the property. I dug down one of the soil pits. I dug down to 50 inches. That's over 4 feet. I did not come across any water table or any soils that were considered hydric. And when you determine whether soils are hydric or not, you look at the soil texture, you look at the soil color, and you look for certain indicators within the soil to determine if they're hydric. There's all kinds of definitions for that. So I determined within that entire 50 inches, there were no indicators of hydric soils. Okay, so we made that assessment on the project site. Then the county came back. I don't know if we want to get into this, but the county then came back and said, okay, we like your assessment. I think they said we agreed to it. Maybe, I'm not sure if they did. But we want you to look 100 feet outside of the development footprint, right? So I can't access those areas. That's private property. So we didn't actually physically go outside those areas. But what I did along with Patrick was we did an assessment based on our existing data, based on the topography that's on the outside within this 100-foot buffer, based on the soil types that are found within this 100-foot buffer. And we determined that it was highly unlikely that those areas outside that 100-foot buffer would support wetlands. So definitely a riparian zone, but not wetlands.
So you mentioned search for a water table. What would define a wetland?
If the water table is up within the major part of the root zone, usually that's defined around 12 inches.
So a wetland zone, what is not part of a wetland zone is when that water table is below the root structure of whatever vegetation is present. Is that roughly?
Yeah, typically it's defined as around 12 inches, depending on the soil texture. Right. And when you look for hydric soils, you have to go down to at least 16 inches, or maximum really 16 inches. So I was looking for a water table, and granted, I was there during a time of the year when it wasn't the rainy season. But still, I thought going down 50 inches, I might find some indicator of wetland hydrology. And there was no indicators of hydric soils, which means that the water table was not coming up near the surface. If it was sitting there for a long time, you would have clearly seen hydric soil indicators.
When did you go visit the site?
I think it was October 4th. So that's you're in the rainy season, but
early
it was,
in the
yeah.
rainy season. if there were, if it were a regular, a zone that would regularly flood or retain water, what, what are the markers that you'd be looking for in that case?
We'd be looking for signs of water on the surface. So you look for like sediment deposits. You look for areas where water had ponded and maybe gone down. You can see leaves and stuff had moved, sediment accumulated on the surface. And if there's a water table near the surface, then you can make that indication by looking at the soils also, if the soils are hydric or not. And you also look for what we call a restrictive horizon, right? So that is a layer of soil that water cannot penetrate, right? So you imagine that this is the surface of the soil, and you have clay layer, maybe a foot below. Water cannot penetrate through that clay layer, and you could assume that water may come up and down right about the clay layer, right? So one of the reasons I went down to 50 inches on that one sample point and 34 on another was because it was in October. So I need to figure out, is there a restrictive horizon somewhere below that surface? Because these are sandy soils, right? Imagine sandy soils, water just perks through. So it perks through, and it needs to hit some type of restrictive horizon in order for that water table to come up. And on the one sample point, I went down to 50 inches and didn't find any clay layer, no kind of restrictive horizon. So it tells me the water's just perking down and then flowing downhill. So we do have a report for that. And then after the county had questions about the 100-foot area, Patrick prepared a second report assessing the area outside the 100-foot buffer. So again, we couldn't physically go out into those areas, but based on the report I did, the samples I took, soil texture, topography, we assessed that it was unlikely that there were wetlands outside of the actual property boundary.
I'd also be interested in hearing from Patrick.
His
Question.
report was,
Right.
So Patrick's report was
I had
made-
a question also. There was something mentioned by one of the neighbors about some flooding on that property, which
Right.
flooded their property as
Sure.
well. Did you see any signs?
I didn't see that, but flooding isn't considered necessarily wetland hydrology.
Okay,
right?
so it doesn't.
Properties flood all the
impact.
time when it's raining.
Okay.
So you don't necessarily look at a flooding event. Kind of the standard is you go out to a site approximately 14 days after a major storm event, and if there's surface water or water below the surface at a certain height, then you might consider that wetland hydrology.
So that doesn't, that water doesn't stay there to impact your wetland study?
Yeah, I mean, I didn't see the flooding. I wasn't there, but I
Okay.
didn't see any signs of
Okay.
the water sitting within the water table for a long period of time. Right. It may have flooded during certain periods of time. I'm sure it does. It's on a slope. You got the road there. There's adjacent houses. So there's all this impervious surface. So it doesn't surprise me that it floods. At least especially down below where the road's at, where I think the speaker mentioned that's sometimes difficult to cross. The culvert's probably too small down there.
Thank you.
Yeah. So did you want to hear from Patrick at all about? Yeah. So he did a report in 2025. We kind of worked on it together to assess this area outside the buffer.
Thank you. Was there a specific question about the? Okay. Sure.
The wetland zone was not impacted even outside the property boundary.
Okay. Yeah, I wanted to point out too that the footprint is 75 feet from the property boundary, where there's no wetlands determined on the property. So there's already a 70-foot, 5-foot buffer on site. So we looked at the county's LiDAR data to get more precise contour information. And we looked at the soils and looked at where Robert did his wetland points. And the topography is very similar, the elevation very similar off-site within 25 feet, which would make the 100-foot buffer. So we looked at that, and we looked at basically, this is very, very dense willows and brush, so it's really hard to get in there. And plus we'd have to get permission from the adjacent property owner. So we did the best we could with the data that we had, and we determined that it's unlikely that there are wetlands off the property boundary.
I get that. I'm just asking what data, you mentioned the LiDAR, what about the LiDAR indicated that the zone outside of the property?
Oh,
was not?
it's just the elevation.
Just the elevation.
Basically, yeah, you would expect to see some pothole features or something, that potentially indicate wetlands.
Okay.
From the elevation data, and then the soils. Yeah, so it's basically that. We can't physically go in and dig soil pits.
Yeah.
Yeah. I also wanted to mention that there was talk about the willows being cleared. There were willows cleared because for him to have access to the wetland delineation, to do the wetland delineation, he had to get a path into the riparian corridor to do the delineation work.
Yeah. I did have one more question. I realize I'm not sure which of you is more apt to answer, related to the remediation from the damage done 30 or 20 years ago.
Oh,
So
sure, go ahead.
there was, the previous owner had done some damage to the riparian zone.
Yes. So
so can you tell me more about the remediation effort?
yes. So I've been involved on this project for 20 years, approximately, and I've been doing biological studies for 30 years on the coast side. So what happened was the property, there was willows that were cleared on one side of the property along that riparian corridor. Some willows were cleared. And then Ms. Lacasia was, they were required to replant that area. And so they replanted areas in there. And then basically the willows grew back and overwhelmed all their plantings. So the riparian corridor is all completely recovered and then some since the time of the clearing.
So maybe my question is, to qualify as properly remediated, those plantings were done how? Was there a previously defined region that should have been replanted or should have been?
Yes, it was exactly where the willows were cleared.
And that was determined by just.
That was me. I
Okay.
went out there and did reports. I went out there when they were doing the planting. I went out there after, I don't know, 5-10 years after, and found that all the plantings had died, but basically all the willows had grown over them. So they couldn't survive, essentially.
The plantings, what were the nature of the plantings?
So they
were
planted
they willows?
They planted willows, and they planted some other currant. They planted some other shrubs that were basically found in riparian corridors, facultative wetland plants that are found in riparian corridors.
So the planted willows died, but the naturally propagated willows overtook them.
Yes, nature just took over and overwhelmed all their plantings. So the taller willows just overwhelmed all their plantings. Yeah, grew back in. And it's you can see it on Google Earth too. You can look closely at the time lapse on Google Earth.
So are you representing the county?
No, I'm representing Ms. Lacasia, the
Okay.
property owner.
Thank you.
Yeah,
Thank you, sir.
thank you. there's really no chance, almost zero chance that the property could flood because the creek is over 100 feet and it's a steep decline down to the creek. The actual creek channel, which I, shown in the reports, is, only 5 feet wide with steep banks. So the channel itself, is, it might overtop its banks, but it would have to go uphill, 80, 100 feet to reach this property and actually flood where they want to build where they want to build their house. So, yeah.
Back to you, Chair Kwan. I believe we're done with public comment and ready for commission deliberations.
Thank you. We will now close public comment for item 2 and begin commission discussion on this item. Are there any comments?
Your mic.
There was a discussion about the street, whether, so I understand the street is paved and the members of the community claimed that that paving was done on their behest, on their dollar. Is it a private road or is it a county road?
My understanding is it's established public right-of-way, but has not been improved to county standards. So
Okay.
it's not maintained by the county,
That's
but
what I
it
wanted
is
to
a
know.
public right-of-way.
Okay.
I wanted to actually clarify too that a fire lane and signs are required by the fire department, so that's already a condition.
While I have you there, yeah. This county map that Lenny Roberts has referred to, dated January 28, 2014, this doesn't look up to date to me.
Yes, we require site-specific studies. It's simply a guideline.
Right. I don't know who updates it.
Well, that's an important point. So thank you for asking because, as has been noted, the precise locations of riparian corridors change over time. And it would not be possible for the county to maintain a map that accurately depicts that delineation, based on the changes that occur periodically. So as Camille mentioned, that map, just like all the other maps we have in our local coastal program identifying habitat areas, those are guidelines. And we always make our recommendations based on site-specific analysis because we cannot guarantee that maps prepared years ago are completely accurate.
I completely understand that, but there are even streets shown here which don't
exist. Yes, that's another fairly common fact in the county. What happens is when people propose subdivisions, they are required to show how access to the new lots will be provided. But until those lots are developed, actually building the roads is not always required. So we call those paper streets. They are right-of-ways established by a subdivision, but they are not always improved depending on whether or not the adjacent lots have been improved.
Okay. And who does that when the lot is approved? Like, whose responsibility?
So subdividers have some choices in the matter. Sometimes subdivisions are accompanied by right-of-way improvements to the extent that allows them to be incorporated in the county maintenance system. Other times, subdividers simply record the subdivision and it becomes the responsibility of future property owners who acquire the lots to develop the necessary access. So we see a variety of those circumstances throughout the unincorporated area.
Okay. Thank you.
Long shot, but I don't know whether you'll have this information. The deck permit from the neighboring lot, 771, was that submitted to this body or?
Yes. Yes, it was quite, it says, they were saying 10 years back.
Right.
And it just should be noted that I don't believe the two are comparable because
No, no.
one is
I-
fully developed.
Of course,
And
I'm
one
not
is-
suggesting that they are
yeah.
comparable. I
Okay.
was looking for more information. It was.
I
this-
don't know whether a biologist was involved in that project. We may have just told them we need a biologist report perhaps, maybe.
Did it come before the commission or was? it staff?
No, it was, I believe the project was withdrawn.
Okay.
Later on, when staff informed them that there's a riparian corridor there. But as far as its exact staff's analysis or any reports that were submitted, I'm not sure.
Okay, I was just looking for any kind of paperwork that was recorded regarding that.
It's online. We can look it up if you like.
Um,
But it's not
It's not-
comparable
it's not
to
com-
this case.
Okay.
Oh, sorry, public comments over.
Okay.
Any other comments, questions from the commission? If not, we can entertain a motion.
Well, here's where I am with this. We're looking at basically a 5-bedroom house. It's looking for permission on the backside to go into an envelope that we normally don't allow. And we're looking for a variance in the front. It's at the same time, no one's guaranteed to get a 5-bedroom house. You know, I particularly have a problem with the front variance. I feel it's being 3 feet is just excessive. I think it should go back and move that line back. You may have to lose a bedroom or two. You still get your economic benefit from your house, but doesn't mean you get a 5-bedroom house. 5-bedroom house, you know, we had one just a few weeks ago and they had 4-car garage, you know, it was nice to see. Have a place to put those cars. There is no place to put these cars except in the 2-car garage. And the reality is a bedroom is a car. I feel the house is just excessive. It's going to probably have to be smaller than it is. I think it is billable. I would continue this item and see if they can, if that's what they wish to do.
Thank you. Any other comments?
Yeah, I can't see this house so close to the street. That's my biggest issue with this home. All the riparian setbacks that have been taken care of, that's great. If the home could be in any way, in whichever way, scaled to the size so that it could be moved back from the street, I would be willing to look at it. but I cannot approve it with 3 feet from the street.
The, in terms of the community's like bedroom quantity, house size, this does seem to be similar in size and in volumetric size, and it is one extra bedroom. It seems like most of the other homes in the area have the standard 4, few smaller ones, 3 or 2, but it's not totally out of the question that a home of that size exists. What's different about this house is that it is a smaller property size footprint because of the constraints of the terrain, but is has a similar living square footage as the structures nearby. So I don't think that is unusual. It seems a lot of effort was taken to address the riparian concerns. The wetland concerns, there's still a bit of an open question. I think that's part of our finding to adjudicate. The other big ask is the setback for the allowance for the front, and it is my understanding that the fire department signed off on any concerns that would be related to hydrant access, to emergency access in the case of necessity. But those aren't really our issues to debate. So it does seem like it's the front setback and whether the wetland description has been sufficiently addressed to our satisfaction. I mean, a 3-foot setback total for the street is a bit uncomfortable. That said, it is in an effort to address the terrain constraints. So I think I would be okay with that. From the street, on the other side of the street, the houses are the visible house is 2 stories. Like all the houses on the other side of the street are 2 stories. That's not new. The 3-story aspect, similar to the project that came before us a few weeks ago, is only visible from the street below.
Yeah, the 3 stories doesn't bother me much. It's mostly a design issue for me. You can treat 3 stories easily, make it not look massive. And the size of the bedrooms, well, I currently living in a house that built in the 40s, and those bedrooms are still bigger than mine. I have to have a double bed, not a queen size bed or not a king size bed. You just can't do it. Bedrooms can be smaller. You can make it work if the number of bedrooms are important. But if it isn't important, you want something bigger, then you're gonna have to do with smaller bedrooms.
I guess I'm not commenting on the size of any individual bedroom, just total living square footage. If you include the ADU, which technically allowed to, is in the neighborhood of the 2,600 square feet, which the neighbors all have.
Yeah, I'm just saying there's a lot of exceptions, and I think to get me to buy into this, I need that front to be moved back.
If I may, Chair, I just have some information to offer that I would hope would be helpful. The first is that this is certainly not the only house in the neighborhood that would have a garage in the, this is not the only house in the neighborhood that would have a garage in the front setback. That's fairly common. The other observation I would offer is with, you know, an 860 square foot footprint, your ability to set back second, third story levels is much different than other situations where you have a larger footprint, which provides more opportunity for articulation and setting back stories. But with such a small footprint, that becomes extremely difficult.
You know, I'm currently in a 900-foot square footprint with 2 bedrooms and, you know, everything else that is 1 story.
Yes, I think, you know, when we evaluate what's a reasonable economic use, we are comparing proposed development to other current proposed development, not development from the 1940s.
Yeah, I looked at the story pools and they look daunting. Because they come out to the streets, almost to the streets. So.
Yes, you know, as
that
it,
is the part, rest of it, I'm like, I can understand. Square footage is not an issue. Square footage means size of the home.
I would just remind the commission that the design review committee approved this, and the commission has had a tradition of relying on the design review committee as, you know, the local expertise in terms of design compatibility. So from a design standpoint, I think with the design review committee's approval and recognizing the constraints of the lot, we believe the project is consistent with the design review standards.
Considering that we're commissioners short and not hearing everybody's opinion, but we could have a 2-2 vote here. Let's just say hypothetically. And, you know, it may be advantageous just to postpone this until we have the 5th commissioner.
Under the scenario where a motion fails to pass, the decision would be a non-action by the commission. That would be final, and it would be appealable to the Board of Supervisors.
Okay.
Maybe I'm looking for some more understanding concerning the fair use statute that is the mechanism, the nexus for allowing for the variance. I appreciate that all properties would be on a case-by-case basis, so it's kind of hard to generalize. But in the hypothetical, let's say that the adjacent undeveloped property decides to be developed, the riparian zone coverage in that property is significantly higher. It would be even harder to conceive of any kind of structure that would work under the constraints on that property. The other conditions of that mechanism are, you know, was the property purchased? I'm going to assume it was. Let's just hypothetically say it was. Let's say that person would be deprived of some fair use of that property otherwise. Seems like a likely high case of likelihood. Under what mechanism would this not apply?
I'll start and I'll let council chime in as needed. So the takings provision is not in the statute. It's a legal principle that's been established by case law. And the test is there a reasonable economic backed expectation for development? And if there is, has the development maximize consistency with the resource protection requirements while at the same time allowing for a reasonable economic use. So in my experience, both at the county and working for the Coastal Commission, I have seen a wide variety of examples of this. I have seen developments in San Luis Obispo County that actually encroach within a wetland and are on piers because they had a reasonable economic backed expectation to use that property. Other properties in the neighborhood had similar encroachments from the past. And so in that case, the commission authorized an encroachment into a wetland that would not be allowed by the Coastal Act because they had an obligation to allow for a reasonable economic use.
I just wanted to add that the county has jealously guarded the prerogative of property owners and the planning commission to make these decisions on the basis of actual applications for structures that attempt to meet these standards. And as a result, we have tried to stay away from answering hypothetical questions about what the development envelope on a property might be, because we know that there are property owners who have gone to court and tried to get a judicial declaration that these rules in the Montecito corridor, as they would be applied in a hypothetical case, constitutes a taking. So we really do want property owners to make their best effort to make a proposal for structures that they think meet the standards in the best way possible, so that the commission can make a case-by-case decision and we keep it out of the hands of other decision makers and keep it with us.
So maybe I'm just looking for a standard or just a rubric to define what fair use, economic use would qualify. Like, can you give me an example of, like, under what circumstances would it not apply? Like, if I own a property and I want to develop it, when would I not have an expectation of fair use economic development?
I think we have an example, and it might even be in the same area, where someone acquired a property for collateral on a small loan that didn't get paid back. And we concluded that based on the information we had about the history of how they acquired the property, that they did not have a reasonable economic backed use to justify any development that would violate our habitat protection standards.
Okay.
I think there's always also been examples where there are differences of opinion on what's reasonable,
yeah,
and to what degree development needs to be scaled back. And I know that's an issue here. And as I think the staff has expressed, we believe that we've asked this property owner to reduce the size. As you've heard from the applicant, they're on round 4 of their design in an effort to deal with this. And as I mentioned, the volume of the home is equivalent to the neighbors. So we don't believe they're asking for anything unreasonable.
When making that, I guess the property consists of the ADU and the main
correct
occupant. What are we allowed to consider concerning the addition of the ADU? I mean, the ADU is obviously not under our jurisdiction to say one way or another, but can we consider the size of the ADU as part of it in our deliberations?
I don't believe so. I believe the state limits our ability to apply any discretion on ADUs that are 800 square feet or under. Property owners are essentially guaranteed the ability to do that. But I do think the commission can look at the overall footprint of the project as it relates to resource protection requirements, including the ADU.
Footprint meaning the property footprint on the lot?
No, the development footprint, including the ADU. And as I mentioned earlier, I think that footprint is very minimal. And so I don't believe that the inclusion of the ADU in any way results in a level of development that is unreasonable or incomparable to what else is in the neighborhood.
in terms of the parking, I also out of curiosity, the ADU, a two-car garage for the ADU plus the primary home does sound a little on the small side.
The project's compliant with regard to parking for the house and parking for the ADU. There was no additional parking required for the ADU per our regulations.
Maybe I would be interested in hearing from our chair.
I thank you for the community, for neighbors, for sharing the concerns with us. Having listened to both sides, I'm comfortable with the amount of due diligence that has been done by the staff as well as the professionals and the length of time that was taken to get this to this stage. And so I'm prepared to make a motion myself. Yeah, so I do make a motion that the planning commission adopt the initial study, mitigated negative declaration, and approve the design review permit, coastal development permit and variance, county file number PLN 2021-00478, by making the required findings and adopting the conditions of the approval listed in attachment A.
I would second.
Thank you. That was a motion by Chair Serrano Kwan and a second by Commissioner Garcia. Commissioner Garcia?
Aye.
Commissioner Gupta?
Nay.
Commissioner Hanson?
Nay.
Chair Serrano Kwan?
Aye.
Thank you. The motion is 2-2, so I look to council and their director for.
As I stated earlier, tie on the motion is a failure to take action, so that's a no action. If the applicant desires to get a final decision on the application, they will need to file an appeal to the Board of Supervisors within 10 days of this action.
Thank you.
Thank you, Madam Clerk. Mr. Monovitz, I'll turn it over to you.
Yes, thank you, Commissioners. So item 3 is correspondence. I have no correspondence to report other than the 5 written communications you received regarding item 2. With regard to our next meeting, that will occur on August 13th. We are planning to be back in chambers. Something changes about that, we will be sure to let you know, but at this point, please plan on being in chambers on August 13th. We've got 3 items, one of them on consent, which is a request from the Granada Community Services District for a general plan conformity determination on a proposed park development on the coast side, near the Burnham Strip, or on the Burnham Strip, I should say. The other 2 items, well, one is a design review and non-conforming use permit for an addition to an existing residence in Emerald Lake Hills. And then we also have a coastal development permit, PAD permit, and use permit for Coastside Community Water District, who plans on drilling replacement wells in a well field that they use to provide domestic water supply to mid-coast properties. Moving on to the director's report, I'm pleased to inform the commission that the rezonings required to implement our housing element are underway. We're under contract with a consultant who has initiated these efforts, and we're moving them forward as quickly as possible to gain full compliance with state housing requirements. Also excited to inform you that construction on the Pescadero water line extension to bring CSA 11 water to the high school is set to commence the first week of August. So a huge milestone and a big effort by the county to address that need. With regard to our work to try and increase the stock of farm worker housing, we are moving forward with the proposed streamlining program. We will be presenting this proposal to the Agricultural Advisory Committee as well as the Pescadero Municipal Advisory Committee right before your August 13th meeting. So I'll update you on how those meeting goes when we meet again. And the county has also, we're moving forward with a farm worker housing loan program. This is a program that's been established for a while. The first iteration, most of those funds were used. Those funds have been replenished, and we are now in the process of outreaching to farm owners and operators about the availability of these loans in hopes of enticing them to improve existing housing or to build new housing. The priority for this first phase of the loan program is to work with the farm owners and operators who have substandard housing units as we identified through our task force work. So that work continues, and I will keep you posted as new events unfold. So that concludes my director's report. I'm happy to answer any questions you may have.
Commissioners have any questions for Mr. Monowitz? No questions? Thank you. Meeting adjourned.